calling from Elizabeth Jolly. I have a lecture here which is supposed to be recorded, but then I see that the status is inactive. I see. Has it commenced? So I don't have to worry about it? Okay. Yes, 243 739 F for fish. No worries.
Hello, everyone. Good afternoon, and welcome back. Right. Today we're going to deal with director's duties, and this will be done in two parts. So in the first part, we're going to look at a few duties, and next week we are going to look at the other half of those duties. Now, director's duties is very, very essential, and it is highly examinable, and it would carry a very high percentage of marks in the final exams. And that's the reason why we probably need to concentrate a little bit more on director's duties, especially the ability to identify the type of duties if a question on director's duties is coming out in the final exams. So not only that you should know the law, but you must be able to identify which law would be relevant to that particular circumstances that you are given in the exams. Now let's look at the learning outcomes for today. You would be learning about duties owed by directors and officers of a company, the duty of directors to exercise care, skill, and diligence. This is a common law duty. Then you have got the potential liability of directors for the debts of a company, meaning to say directors must prevent the company from entering into insolvent trading, the duty of directors to retain discretion, and the duty owed by directors to act in good faith in the interests of the company and for a proper purpose. Now, generally, when we are talking about directors' duties, we refer to the general law. General law will mean common law as well as equity will be applicable. And Section 179 of the Corporations Act 2001 tells us that both equity and common law will be applicable under the heading of general law. And then we'll look at specific sections. Today we're going to deal with Section 180, Sub 1 and Sub 2. We're going to also look at Section 588G and 588H. And we're going to look at Section 181, Sub 1, Sub A, and Sub 1, Sub B. So these are the duties that we're going to look at. And next week, we will look at sections 182 and 183 in terms of conflict of interest, misuse of position and information, and also how would you deal with when you have material personal interest. You make a disclosure, and disclosure of material personal interest would fall under section 191. We'll also look at related party transactions next week. When we talk about fiduciary duties, we are talking about duties of utmost faith. Because a company is an inanimate object, you use directors to act on behalf of those companies. And now these directors must act in utmost good faith when they are making decisions related to the company. And that's the reason why we call it fiduciary duties. And fiduciary duties has its origins from equity. Now, directors are required to act in good faith. What is good faith? to act honestly. All right, so that's what we talk about good faith. And they must act in the best interest of the company. And we need to determine who is the company. When you are a director, when you say, I have to act in the best interest of the company, who is deemed to be the company? That's what we're going to determine today. All right, we're going to look at who is considered as the company. And the directors must exercise powers that is vested to them through the Constitution for a proper purpose. So if you're given the powers, you must exercise those powers for the reason it has been conferred to you as a director. And you can't use it for your own benefit or the benefit of other persons who are related to you. Then you have to retain discretion. Retaining discretion means you must not allow other people to influence your decision-making ability. So you retain discretion. And a director must also avoid conflicts of interest when his interest goes against the interest of the company. That's when there is a situation of conflict. So we need to also ensure that the director does not put himself in a position where he is in conflict with the company. And then you have got the common law duty of exercising care and diligence. When we talk about the common law duty, this is similar to the law of negligence. All right, in tort. What do we remember from the law of negligence? A person has the duty to act as a reasonable person would. And in our circumstances, it will be a director who must make decisions as a reasonable director in their position and circumstances would. And if they do not follow what a reasonable director would have done, therefore, they would have breached their duty. So that's what we're going to look at in terms of exercising care and diligence. Now, all these duties are supplemented by the Corporation Act under Section 180 and 181. So that's what we're going to look at, and of course, Section 588G. This is an overview of all those sections that we will be looking at in relation to directors' duties. We'll start off with Section 180, Sub 1, which deals with care and diligence, and Section 180, Sub 2, which talks about business judgment rule. Now, we do not want to scare the directors generally from making business decisions. There are business decisions which may fail. There are business decisions which may go wrong. Now, if we scare the directors too much, they would not be making decisions which would benefit the company for the fear that this decision will fail. In such circumstances, if the directors are able to prove that they have satisfied certain requirements, in that case, the courts will allow, or the law will allow them, the defense of business judgment rule. But please remember, the business judgment rule is a defense available only for Section 180 Sub 1, which means it cannot be a defense for 181, 182, 183. You cannot use it for any other sections. When you discuss Section 180 Sub 1, you will need to discuss Section 180 Sub 2. They come together. All right? Next, we look at Section 181 Sub 1, Sub A to be specific. Directors must act in good faith for the interests of the company. All right? So who is the company that they have to act for? Now, is the company members? Is the company a commercial entity? Is the company creditors? Is the company, if they are within a group, the other companies in the group? Or are they employees? Whom do we consider as company? This is what we're going to look at today. We need to know, because if a director does not know to whom he owes the duty, then it's going to be quite challenging. All right? So that is the next thing that we will look at. And next week, we'll look at improper use of position and improper use of information, and also the criminal equivalent of those sections mentioned under Section 180, 181, 182, and 183. Though we do not go in detail on the criminal offense, but we will look at the civil side of the duties. And Section 189 is where the director has reliance or relied on advice provided by someone else, someone who's got a capability of giving the advice. Now, in such a case, can the director avail themselves a defense saying, I have relied on the advice of a professional. I have relied on the advice of a person, another person, whom I thought reasonably had the capacity to advise me. Would that then be a defense that the director can use? These are the things that we will consider. Now, generally, when you look at duties of directors, they do not owe duty to a single member or a single shareholder. They actually owe a duty to the members as a whole, collectively, to all the members. It doesn't matter whether they're majority shareholders or minority shareholders, they will have a duty towards all of them as a whole. However, if you look at the case of Galvanics and Brunninghausen, this was a very different case where they had two shareholders and they had two directors. So these two shareholders were also the directors, and one of them did not actively participate in the management of the company. And because of that, the one that was actively participating and the one that was not actively participating had a misunderstanding, a quarrel, and out of which one party decided that he would resign as the director and he was to sell his shares to the other party. Now, unknown to the party who was selling the shares, that there was an offer being made for all the shares of the company at a higher rate. And this particular director did not mention this to the one who was selling off the shares and bought his shares at a lower rate and made quite a reasonable profit. And when he found out, obviously he's not happy, he decided to bring an action against the director. And the question before the court was that, did this director owe a duty to the shareholder? What do you think? The court said yes. In these circumstances, it is quite different because here, this particular shareholder was relying, was trusting the information that was provided by this director, and that was the reason why, in this case, they held that the director owed a duty to a single shareholder. However, the facts of this case will be limited to its circumstances, and it may not be extended beyond the facts that's been given. Right? Now, common law duty of care, skill, and diligence. When making a business decision, a director must not be negligent. Now, please highlight the word business decision. That is the key. When you go into the exams and look at the question, and the fact seems to suggest that they are making a business decision, or they're trying to make a business decision, you immediately will be prompted to discuss section 180, sub 1, and also the common law duty of care, skill, and diligence. Because when you're making a decision, you have to be careful, you must exercise skill, and you must be diligent when you're making the decision. Alright? And if you can prove all of this, then that is a good decision. If not, then you have not come up to the standard of a reasonable director in your position and in your circumstances. Alright? So in the exam, if you see any decision, for an example, XYZ Proprietary Limited, or the directors of XYZ Proprietary Limited were considering whether or not they should invest in JYL Proprietary Limited. Now that is a business decision, an enterprise decision. And that decision needs to be debated, needs to be taken with care. And if one of the directors signed off the announcement or the document while playing golf, have they discharged their duty? If I'm a director and I'm supposed to sign off a document, which is very important, and I'm playing golf, and somebody gives me this document, I just sign it off without reading it, have I discharged my duty of care? I have. Would you, as a director of a company, play golf and sign off a document without reading it? 180 sub 1 talks about duty of care and diligence, and the test is, would a reasonable director in the position of the defendant director and circumstances of the defendant director would have decided the same? If the answer is yes, then there is no breach of duty. If the answer is no, then there is a breach of duty. So what you need to do in essence is compare the directors. Compare the one who has made the decision and compare him against a reasonable director in his position. Would this person make the same decision or take the same decision? If the answer is yes, then there is no breach. If this director would not have taken the decision that was taken by this particular director, then they have breached the duty of care. Get it? Okay. Now, it is not significantly different between common law and Section 180 duty, except in relation to remedies. Now, under the common law, who can take action? The company takes action. All right? Under the statute, ASIC takes action. So that's the difference, in essence, in relation to who initiates the action and also the remedies that is possibly available for the breach. Now, all directors must satisfy the minimum requirement that is expected of them. And the minimum that is required of a director is that they must familiarize themselves and pay continuous attention to the company's affairs, and they must use objective standard of care and not be limited by the lack of knowledge or experience, ignorance, and inaction, and they must make reasonable inquiries when they have reason to do so. Now, what happened in the case of Daniels and AWA Limited? All right, in this case, AWA adopted a managed hedging strategy against foreign currency, and they actually suffered loss. There was this guy who was looking after it, and he was not quite well versed with hedging, and he made a loss, took a loan to cover the losses. And an auditor was appointed to come and audit the internal system of the company, and they found out that there was this internal system which was not sufficient because they left this person without any proper supervision. And this information was conveyed to the manager, however, was not tabled to the directors. Subsequently, the losses became huge, and the directors found that out and decided to take action against the auditors who failed to report the finding to the board of directors. So the auditors get sued, and they said, look, yes, we are at fault, but so are you. So they countersued for contributory negligence. Okay, you sue the auditor said, yes, okay, we didn't report to you, but you as well did not bother to check on your system. You did not want to go and find out what was happening. Just because you were not aware of the fact of foreign exchange or hedging, it does not mean you just leave your employees to their devices. So that's what was said in that case. Now, next is skills. When you have skills, you are expected to live up to the skills that a reasonable person with that skills would behave or would discharge their duty. So if we are looking at a particular director who professes to have the skills of a professional accountant, then we compare this director with a reasonable accountant with the same skills and decide whether or not a reasonable accountant in the position of this particular director would have made the same decision or would have exercised their skills in the same manner. If they would have, then this particular director has exercised his skill up to the required level. If not, then he has breached his duty to perform the transaction according to the skills required. So here it refers to talents, training, and knowledge, and directors are expected to understand companies' affairs and when they have a particular skill, to use it as the same level as a reasonable person would. Now, the case of Wines and ASIC is about a case on a takeover bid. Now, what happened in that was that the forecast, the profit forecast that was given in relation to the takeover was actually flawed. And now, the chief financial officer who actually came up with this projection was found to be in breach of his duty. And the case went to court, and the question before the court was that would a reasonable chief financial officer in the position of this particular officer would have given or provided a wrong profit forecast? The court said no. In that case, a reasonable chief financial officer would not have made this mistake of providing a wrong profit forecast, and therefore in this case, this particular chief financial officer did not satisfy the skills up to the standard of a reasonable person or a reasonable chief financial officer. So here, Wines breached Section 180 as he was not proactive in checking the accuracy of the forecast, and he was judged on the basis of what a reasonably competent chief financial officer would have done. Next, we look at diligence. What is diligence? What does the English word diligence mean? You diligently come to class. So you're diligent. What does diligent mean? We looked at skill, now we looked at care, now we're looking at diligence. Hardworking, careful. Alright? So you take effort to do something, and that effort is diligence. Alright? So here the directors must attend board meetings unless there is good reason for absence. Now, if the director is sick and is not able to come for board meetings, that's fine, acceptable. In the exams, there was a situation where they said a director called Betty could not come for a meeting because her husband was sick, her spouse, her partner was sick. And there were students who said, that's not good reason. If your partner is sick and you're not coming to a board meeting, if that's not good reason, what is? Alright? Now that is considered good reason. Please make sure you remember that, okay? And if a child gets sick and you're not able to come, that will also be a good reason. Now, the reason that's not good is that if you go on a holiday to Bali for fun, okay? That would not be a good reason to miss the board of directors meeting. But if you go on a trip, on a company trip to promote the company's business, would that be a good reason for absence? Yes, it would. All right? And also you have to obtain basic understanding of the company's business. Also keep informed about the company's affairs and pay continuous attention to the affairs of the company. So you know what is happening in the company. You know the business of the company. You know the financials of the company. So you are keeping an eye. You are being diligent. You're being careful in the management of the company. Right, let's look at ASIC and Healy. Don't know whether it works, but we can try.
You want to create a stunning website? I've already done it with Wix. Let me show you how it's done.
That's not the program.
Thanks, Tiki.
Well, I salute you as one of the few who've read the whole of the Centro judgment. Is it the landmark decision that ASIC claims?
It is a landmark decision, but not quite for the reason ASIC claims. What it does is to take the standard of care in relation to financial statements up a few notches. The old cases said that directors have to have basic financial literacy, but now what's being said is that the directors have to do more. They have to have a basic understanding of accounting standards, sufficient to know, for example, the difference between current and non-current liabilities.
So if you're a non-executive director sitting on a listed company board and you've got some expertise in the company's business like research or design or communications, but you don't have much skills in the accounting area, and I'm sure there are a lot of directors like that, how should you be feeling now?
I think this is all about public companies. I think the standard of basic financial literacy is probably the same for the small company, but for a public company, what you have to do is actually read the financial statements before you sign off on them, and you have to apply the knowledge you have about the company, gained from any source, to test what's said in the financial statements and then to ask questions if you're not satisfied.
Now, Justice Middleton, rather importantly, said the directors could not rely on the external advice of auditors or other experts as a defence. Doesn't this change the due diligence defence of reasonable reliance that we always used to have?
Well, no, I don't think he said you can't rely. In fact, what he said was that for the most part you can rely on technical expertise being provided to you. But there are limits to reliance, and I think that's what you're getting at. Right. You have to apply an inquiring mind. You have to have an assessment of just what you think the financial statements are really saying.
Didn't you have to have that before, though? You had to ask reasonable questions, didn't you?
Well, a lot of directors, I think, might have thought that if they're talking about signing off on the financial statements, the question they should ask is, are the auditors satisfied and are the audit committee satisfied? And if they get yes answers to that, then they sign. But now Justice Middleton says, no, they have to read, they have to apply their knowledge of basic accounting standards and make sure they personally are satisfied. And they have to do all that with an inquiring mind.
Now, interestingly, with Centro, I mean, at issue was this $2 billion of undisclosed current liabilities. PricewaterhouseCoopers signed off on the accounts. Why didn't they pick it up?
Well, at the time there was some confusion about the transition from GAAP accounting standards to the International Financial Reporting Standards.
So this is in terms of classifying what was current and what was not current?
Particularly on that issue. It has to be said that Justice Middleton was careful not to make any particular finding against the auditors because he explained that he hadn't had evidence directed specifically to their position. But they did sign off on the accounts. And that obviously was one of the things the directors said that they relied on.
And yet the judge said that the directors should have spotted this. Why?
Well, it was so obvious in the judge's assessment. He read the new accounting standards and he said quite clearly that this $2 billion or so it related to liabilities that were due in the current year. That clearly meant to him that these were current liabilities.
It was also in their board papers, I know. I mean, it was in a schedule to their board papers, as I understand it. And one of the defences of the directors was that they were snowed by volumes of papers and had to get through an awful lot. But that didn't fly with the judge. No,
certainly not. This is an important statement. There were about 3,000 pages of material in relation to the financial statements, and each board pack every month was about 450 pages. What the judge said was it's within the control of the directors to determine how much information they get.
Now, the facts of this case were relatively simple. What is going to happen when we've got more complicated accounting issues, you know, hybrid debt, hedging positions, the issue of trading while insolvent?
I think we're starting off on a new chapter in this part of company law. I think that when you're looking at more complicated cases, the issue will be just how far into the accounting standards are directors of public companies now required to get. Clearly, Justice Middleton thought this was an obvious and straightforward point, but as you say, there'll be harder cases.
Let me ask you, I see the James Hardie case is now headed to the High Court. That's got the position of directors front and centre. Do you think this decision will have an impact on it?
Well, it depends what issues are ultimately raised in the High Court, and we don't have the full scope of the High Court hearing yet because there's still a prospect that there might be applications for leave to cross-appeal by the directors. It's possible that issues of reliance on others might be raised in a somewhat different context, whereas the Centro case was all about financial statements and reliance on the auditing team. In James Hardie, it was all about a market announcement claiming that the foundation for asbestos victims was fully funded. But again, the directors raised at first instance issues about reliance on others in the context of what Justice Gazelle found was their approval of that market announcement. If that issue comes to the High Court, then what is said in the Centro case will be relevant, but we might get an authoritative pronouncement by our highest court on just what extent, to what extent directors can rely on others in making difficult decisions.
Dr. Bob Weston, thank you very much for your perspective tonight.
It's a pleasure.
Okay, So that has, in a nutshell, has already explained what ASIC and Healy was all about. Now, a 1.5 billion short-term liabilities was actually classified as a non-current liability. Now, short-term liabilities, your accounting students, is it classified as a current liability or non-current liability? Current, all right? It was supposed to be classified as a current liability, but in this case, the directors did not pick it up. They actually signed off the financial statement. As you can see, the auditor signed it off, and they just happily gone on to submit the financial statement. And when the directors were put to task or questioned on how did they actually sign off the financial statement, they said they relied on the experts, but the court have now said, just because there are experts who are telling you that this is how it is, it doesn't mean you blindly follow that. You have to use your inquiring mind and look at it. And if you're not sure, you're supposed to ask for clarification. And if you don't, you would still breach your duty of care. All right? Do you think this is a good decision? The walls are saying yes. Okay. What do y'all think? Is it a good decision? Yes? No? Don't know? Don't care? Okay. Never mind. All right? Next, we look at James Hardy's case. That's ASIC and Helicare. They released a statement on ASX that the company had built a foundation and they had sufficient money in the fund to actually satisfy all the claims that could be made by asbestos sufferers. However, they were short by a couple of million. Actually, they were short by $1.5 billion in the fund. All right, they said they had sufficient fund for all the claims that may be made against James Hardy, but then the funds were not sufficient to meet these claims. All right, okay, let's just look at ASIC and Helicare.
Stop! Stop! Stop!
Okay.
And it's taken almost 8 years and a trip to the High Court, but ASIC has finally and conclusively won the case against the 7 former James Hardy directors who were accused of breaching their duties when they approved a press release that said asbestos compensation scheme was fully funded. Here's ASIC Chairman Greg Metcalfe.
Directors have an obligation to make sure that what they issue to the market is accurate. We want Australians to be confident and informed when they invest, and that, you know, particularly that the gatekeepers, being directors, can be relied upon in terms of doing what is expected of them.
I'm not sure that there was any surprise that the High Court confirmed the thing, and all the directors, I guess, were taking notice of the previous ruling. But I guess it confirms that that's it. Directors have to now watch everything that goes out, and they can't just leave it to management.
But they can't, and they have to, you know, make sure that they understand the implications of big decisions. So, I mean, that was also confirmed in the with the Centro decision as well, that, you know, the auditors tell you something. If you don't understand it, you really need to make sure that you ask questions of them and find out what it means before. Otherwise, you can't be fully informed when you vote on a board decision.
And Steve, this plus the Centro decision, and there's been a bunch of developments legally, haven't there, which have kind of changed the role of directors, or at least changed the way they must think about their roles.
I think it's changed the role. I think it's kind of raised the bar slightly. In the past, you would have assumed, a director would have assumed, that they could actually rely on the combination of their management and their external advisors, so their auditors, whoever, the actuaries in the case of the James Hardy case. It's quite clear after those two cases that they've got to show that they've done their own due diligence. I'm not sure how a James Hardie director could have second-guessed the actuarial assessments of how much money was needed to provide for liability over 40 years, but the courts are saying you've got to at least go through the process of coming to some sort of understanding independently of your management and the consultants. And so I suppose that's the message. Be really, really careful, be really afraid, and do a hell of a lot of work before you sign anything.
Who'd want to be a director? I mean,
Well, so I was wondering, I mean, people think directors make a lot of money. Most of them make a pittance, especially at the smaller company level.
and compared to the risk they're taking.
Absolutely. I mean, your home's at risk, your career's at risk. I think we might be chucking the baby out with the bathwater a bit here.
And where this is really going to impact is not the top level companies, the top 200. It's really the companies that are smaller. They're going to have enormous difficulty attracting directors to go onto their boards, and I mean they're the ones that arguably, should be looking for directors to help them with performance, not directors that can, help them tick all the boxes.
Well, but I remember, it wasn't that long ago that they brought in the business judgment rule. That was meant to take the, take the pressure off the directors. Everything, it was okay because you protected, you had a defence that, you made a judgment, so it turned out to be wrong. That was okay, but in fact, it's ever since that was introduced, it's all gone the other way.
Yeah, well, I'm sure Joe's right that there's going to be an issue at the smaller end. I actually do think there's a big issue for the big companies as well, because they're large and they're complex. And we saw in the Centro case, the volumes of material the directors were supposed to be able to not just read, but understand and test. If you're a director of a company like BHP, it's not possible for you to have the kind of understanding of the detail of that business that the management have and that the external advisors have. So if I were a non-executive director and have no ambition to be one, I'd be really worried about those sort of judgments.
Yeah, but I think there is a danger in taking, these circumstances, these facts, and generalising from this decision too much.
Well, I guess that's what we do, isn't it?
I know. Well, we have to be. Yeah.
Okay, so we've looked at two cases, and two cases seems to suggest the same thing. You have to be diligent, and you have to have an inquiring mind, and failure to do so, you would have breached your duty. But Helicare is more interesting is because non-executive directors were also found liable to be in breach of this particular duty of care. So in your exam question, if you do have non-executive directors, then you have to also say that they do have a duty to discharge, and they may also be liable, taking the cue from ASIC and Helicare. And ASIC and Adler is a very interesting case. It is one of the cases that you can use for all your sections, from 180, 181, 182, 183. All of it you can use ASIC and Adler. All right, that's one case. If you forget every other case, you can remember to put Adler. Now, Rodney Adler was one of the directors of HIH Insurance. If you all remember the HIH Insurance collapse. Now, this particular director had actually taken some funds through its subsidiary and used the monies of that particular holding company to shore up the shares of the holding company, which means I now take the funds out through the holding company and invest it into another company who then purchases the shares of the holding company. In other words, the holding company is buying its own shares. And then some other monies were transferred to companies that were under Adler's name and his wife. And these monies were actually channeled somewhere, which made a lot of losses, and about $10 million were lost. Now, when HIH collapsed, what the liquidator did was that they tried to find out all those transactions that happened prior to the collapse, because they want to now see whether or not they're able to recoup the amount of money. And that's where they discovered ASIC and Adler, and it was found that they have breached their duty of care, and Adler has been banned from being a director for 20 years and his friend for 10 years. All right, that's just one breach. He's got multiple, so it's all combined and it's become big. Right. The next thing we look at is business judgment rule. The business judgment rule has its origin from the American jurisprudence. It is actually taken from the American jurisprudence, where they try to give some form of protection to allow the directors to make decisions, business decisions. We do not have crystal balls. Can we see our decisions actually happening and bringing us results? Can you foresee? If you were a director, would you know this decision is going to bring you profit? You would think it would, but can you guarantee it's going to bring profits? No. What if it doesn't? What if it fails? Does that now mean the director has breached their duty? If that is the case, then what will happen to all the directors? They'll stop making business decisions. They'll be so afraid of making business decisions that they will spend hours together in the boardroom trying to figure out whether this is the right decision to make. And they may miss out the opportunities that may have arisen. And this is a way to balance the returns to the members or the shareholders and also a duty to the company. So there needs to be a balance. Sometimes you need to take that risk to get that opportunity to capitalize on it. And if directors are found liable every time they're trying to capitalize on the opportunity, then nobody will make business decisions. They'll just sit there and wait until they're 100% sure that decision is going to bear some fruit, then only then they will embark upon it. Otherwise, they're not going to do that. So realizing this, the business judgment rule was introduced into the Australian jurisprudence. So now we have got section 180 sub 2. Here, a director may avail themselves of this defense if it can be proven that the director, when making the decision, acted in good faith and for a proper purpose, had no personal material interest in the decision that was being taken, acted on an informed basis, meaning to say they actually did some due diligence exercise, they were informed that these are the outcomes that they can look out for, so they acted on an informed basis, and last but not least, rationally believed that their decision was in the best interest of the company. Now, rationally believed here is a subjective approach, which means did the directors believe that that action was in the best interest of the company? So we looked at a subjective approach. Here again, the courts are not interfering in the decision, they are only looking at the process that has been undertaken in order to arrive at the decision. If the process was in order, the courts will then say they have rationally discharged or they have rationally believed that it was in the best interest of the company. And if you can prove all of these four elements, then you can avail yourself with the defense of business judgment rule. But what if you can't satisfy any one of this? If you cannot satisfy no material personal interest, can you succeed? You can't, all right? This is you see the word and, it's a conjunctive, meaning to say you have to prove all the elements, not any one of it. If you can't prove any one of it, this defense will fail. All right? And the decision of rationally believing to be in the best interest of the company was considered in the case of ASIC and Rich. Now, in this case, ASIC alleged that Rich had breached section 180 sub 1. This was about the OneTel company, where there was a failure to assess OneTel's financial position. And he failed to inform the board and did not even have a system in place. And under the section 180 sub 2 defense, he alleged that this was a business judgment. And the case was dismissed. ASIC actually lost this case. And the court said, exploring its purpose, and affirmed that to protect the authority of the directors and not to insulate them, not to give them a defense to protect them, but to allow them to make business decisions which may become wrong. All right? And if the directors believed that the decision was made in the best interest of the company, then section 180 sub 2 sub D is satisfied. So for more discussion, you can actually look at 11-220 of your text. Okay. Now, there are additional requirements that the courts will take into account to assess whether or not that decision is a good decision, like the importance of the business judgment to be made, time available for obtaining information, costs related to obtaining information, directors' confidence in those exploring the matter, state of company's business and nature of company's demands on the board's attention, and whether or not material information is reasonably available to the directors. These are some of the other considerations that the courts will take into consideration. All right, so with that, we're done with the duty of care and diligence, or care, skill, and diligence. Under the common law, you know we're looking at something similar to the law of negligence. Would a reasonable director in the position of this particular director and the circumstances of the dependent director have decided the same? If the answer is no, then they have breached their duty of care. Now, similarly, the similar position is found under section 180 sub 1. Now, under statute, however, you have the defense of business judgment rule under section 180 sub 2. We have also looked at, when we talk about what is it exercising skills all about, and diligence. And there are cases related to the same which you are required to know. The next we look at under duty of care still is the duty to prevent insolvent trading. We did insolvent trading very briefly when we started off with incorporation, when we said that the company is a separate legal entity and it is separate from its members and participants. However, when we looked at the piercing of the corporate veil, we said if the directors have indulged or allowed the company to enter into a transaction or insolvent transaction, then the corporate veil will be pierced and the directors will be found personally liable for that transaction. All right? So in this case, we're looking at if the directors have breached their duty to prevent insolvent trading and the elements that you need to prove. First, you need to prove that that particular director was a director at the time when the debt was incurred. It's very important. So he must be a director, or he or she must be a director at the time the debt was incurred. Second, the company was already insolvent or became insolvent due to the debt. All right? It was already insolvent or became insolvent because of the debt. Third, the company, there are reasonable grounds for the director to suspect that the company is insolvent or would become insolvent. So now the director has reasonable grounds to believe that the company is insolvent or would become insolvent. And the last requirement is the director fails to prevent the debt from being incurred. Now you have to satisfy all four of these elements in order for you to succeed in establishing the breach of duty to prevent insolvent trading. The next question you need to determine is, when was the debt incurred? All right? Is the debt incurred at the time of entering into the contract? Or is the debt incurred at the time after delivery? When is the debt incurred? Timing is very, very important. Now, to determine the timing, you can look at section 588G sub 1A. Okay, so those of you who've got the statute book, you can refer to section 588G sub 1A. 1 capital A. Right here. For the purposes of this section, if a company takes action set out in column 2 of the following table, it incurs a debt at the time as set out in column 3. So it actually shows you when are the debts being incurred. All right? If the action of the company is the payment or paying of a dividend, when the dividend is paid, or if the company has a constitution that provides for the declaration of dividends, when the dividend is declared, that's when debt is incurred. All right, so that's the timing when the debt is incurred. When you're making a reduction of share capital, then when the reduction takes effect. Buying back shares, when the buyback agreement is entered into. When you're redeeming redeemable preference shares, we are looking at when the company exercises the option. Issuing redeemable preference shares, when the shares are issued. Financially assisting a person to acquire shares, when the agreement to provide the assistance is entered into. Entering into an uncommercial transaction within the meaning that's given under section 588FB when the transaction is entered into. So this is some of the guide that has been given as to when the timing of the debt has been incurred. Now timing is important because we say that the company has become insolvent due to the debt. So the timing of the debt becomes highly relevant for us to determine when the debt was due. Okay. Okay, now let's look at each of the elements in detail. Who is liable? We know a director is liable under section 588G sub 1. Company must positively incur a debt. What does that mean? It means they must incur the debt. It can't be something that's incurred out of accident. For instance, if the company was fined, and it's a company that deals with transportation of petrol, and due to some mistake or some negligence, there's an oil spill. Now they have to clean the oil spill. That's money. There's going to be money that needs to be used to clean this oil spill. So is it a debt that has been voluntarily acquired? No, this is not a debt that has been voluntarily acquired. So that's what we mean by company must positively incur debt, which means it must be a voluntary debt. Okay? Timing is important. We have already looked at that. Company is or becomes insolvent due to the debt. Now, insolvency is defined under section 95A is when the debt is due and the company is unable to pay, that will be deemed to be, company will be deemed to be insolvent. All right? When the debt is due and the company is unable to pay, then the company is deemed to be insolvent. Now, an objective test will be applied for reasonable grounds for suspecting. It cannot be based on whims and fancies, or you just suspect because you've got a hunch. No, you can't do that. You must have reasonable grounds to suspect that the company was insolvent, and this was considered in the case of Metropolitan Fire Systems and Miller. And also, there was no failure to prevent incurring the debt in contravention of section 588G sub 2. Now, when you talk about 588G, once you have satisfied all the elements and you think that there is a breach of the duty to prevent insolvent trading, the next thing that you will consider is the defenses under section 588H. Yes, the director has breached the duty to prevent insolvent trading. Can he avail himself with one of the defenses that's provided under 588H? That's what you need to consider. When we consider duty of care under section 180, once you've established that the director has breached that duty, the next thing you look is whether or not the director can avail themselves with the business judgment rule defense. So here you look at whether or not they would be able to avail themselves with the section 588H defenses. Now, section 588H sub 2, reasonable grounds to expect solvency. If the directors can prove that they had reasonable grounds to expect solvency, now that would be a defense. However, reasonable grounds does not mean wishful thinking. All right, wishful thinking is, oh, we might win a lottery tomorrow. That's not reasonable grounds to expect solvency. But however, if you know that the company is expecting some payment from its creditors or from its debtors, tradespeople, it is supposed payment. Payment is supposed to come through in the next 60 days. Now that is reasonable grounds to expect solvency. All right? And this was considered in the case of Morley and statewide tobacco. Expectation of solvency based on hope is not sufficient. Now, another time when directors are saying, oh, we expected solvency, but the company was going through endemic cash deficit. There was not enough cash. They were having endemic cash problems. Now, in such a circumstances, it is going to be very, very difficult for the directors to prove that there was reasonable expectation of solvency. All right, so if the company is going through a cash problem, then it will be difficult for the directors to prove that they expected reasonable solvency. Next is delegation and reliance on others, section 588H sub 3. Each director must inquire if suspicious of company's financial position. Now here you can't simply rely on whatever statement that's been given by others. Again, if you looked at Santro's case and Halifax case, you will know that you can't just simply rely. You have to have an inquiring mind. But after the inquiring mind, if you were satisfied that whatever advice was given was good, then you may avail yourself with the defense under section 588H sub 3. Now, absence from management. There's two subsections which is highly examined, 588H sub 2 and 588H sub 4, absence from management. So I gave that example where Betty was absent and because her husband was sick. Now the question is, this company has gone into insolvency. Can Betty rely on the defense under section 588H sub 4? All right. Was it a good reason for her to be absent from management? Looking after her spouse or partner was a good reason, and therefore in this case she may avail herself with that defense. However, let's look at the case of Deputy Commissioner of Taxation and Clerk. What happened was that it was a husband and wife company. They were both directors of the company, but the wife never participated in any management. The only thing she did was sign off all the documents that the husband showed to her. So she just signed off. In fact, in one of her depositions, she actually said, I used to sign off documents on one hand, and the other hand I had my frying pan. Okay? So that's how she actually ran or managed the company, by not attending any meetings whatsoever. So finally, the company was, the directors were alleged to have entered into a transaction which was against insolvent trading. So the question before the court was, can the wife now say she was absent from management? Can she use that defense that she was absent from management? She was not even in the management in the first place. So how can you be absent? All right, the court said absent from management doesn't mean that. You must have participation. This is a total abandonment of management. So you cannot avail yourself with this defense. And that was what was held in the case of Clark. Section 588H sub 5, all reasonable steps to prevent incurring the debt was taken, and voicing objection, just mere voicing of objection will be insufficient. Again, this may be examinable. So you have the case of Byron and Southern Star. So there are only particular subsections are normally examined. So one of the best ways to do that is put that in the cheat sheet and make sure you have worded it into your own words, because if you copy it verbatim, you'll not get any marks. Next is the duty to retain discretion. The duty to retain discretion means you have the right to make decisions without anybody influencing you. And directors cannot fetter future discretion, but nominee directors may if constitutions permit. Now, nominee directors, whose rights do they represent? Whose rights do nominee directors represent? The holding company, or the company which has got interest in the investment. So they appoint a director who would be in the board of directors of the company that they have invested in. Now, this nominee director normally will look out for the interests of the party that they are representing, not the company per se. All right, so I am a director, but I am a director because, say, Bank ABC Limited has given a big loan, and to protect their interests, they have appointed a nominee director, and I sit on behalf of that bank in the directorship of this particular company. Now, to whom do I owe my duty? Is it to the company that I'm sitting as a director, or do I owe my duty to the bank that I am representing? Very difficult question. Difficult situation. General rule, I will owe a duty to the company that I'm sitting on the board. But then, if the Constitution provides for nominee directors, in such a case, then I can owe a duty to the person I am representing. Next, we look at duty to act in good faith. All right, good faith is very easy. You just act honestly. All right, Section 181 requires directors to act in good faith in what they believe to be in the best interest of the company and for a proper purpose. We'll deal with proper purpose in a short while, but we need to now consider what is meant by the best interest of the company. So I told you there are several stakeholders we need to consider. The first stakeholder would be members. The second stakeholders that we will consider would be creditors. The company as a commercial entity. The third stakeholders we'll consider would be creditors. The fourth stakeholders that we will consider would be a company within a group. And last but not least, we'll look at employees. Now, we need to determine whether each of these stakeholders are considered to be the company for the purposes of deciding in the best interest of the company. When Resima's case, good faith includes fiduciary duty to act in the best interest of the company and proper purpose. And this was also decided in R and Chu, where they said good faith includes fiduciary duty to avoid conflict of interest, not to misuse power, and not to make secret profits, as well as take away companies' assets. Now, best interest is subjective, as was said in Smith and Fawcett. They must exercise their discretion bona fide in what they consider, not what the court considers to be in the best interest of the company. So what did the directors feel? Did they feel that they acted in the best interest of the company? The general rule is that when we talk about best interest of the company, we are talking about the company as a whole. It does not mean you owe a duty to a single shareholder or a member. You owe a duty to the whole company, which includes majority shareholders as well as minority shareholders. You have to balance their rights. And normally courts are reluctant to interfere where directors have acted honestly or they believe they have acted honestly. All right? Now, there is a problem in relation to duty to present and future shareholders. In this case, we are looking at the company as a separate or commercial entity. When we say we are looking at the company as a commercial entity, what does that mean? What does that mean? It means the company is now separate from its members, separate from its directors, separate from everyone. It is just a legal person. It's like you and me. We're just looking at the company as a legal person. That is what we mean by commercial entity. Now, in the case of Greenhall, here we see that the company as a whole does not mean as a commercial entity. This is an old case where they said, look, when we say that you owe a duty to the company as a whole, it means you are owing the duty to the members, not the company as an entity by itself, not a company as a legal person. That was the decision that was decided in Greenhall's case. In Greenhall's case, they said, when we talk about company's best interest, we're talking about the members' as a group, as a whole. However, there was a different decision in the case of Darwell and North Sydney Bridge and Tile Company. In this case, what they said was that the case involved a takeover bid. All right? There was a takeover bid that was offered, and there was a generous offer being made to the shareholders. However, the directors do not want to accept this takeover bid simply because they were of the opinion that if the company proceeded on, it would be able to make a much better profit at the longer run. So the short-term profit is not as good as the long-term profit that is going to come up ahead. And because of that, they have decided to stop the takeover bid. Now, the question before the court was on whose best interest must the directors act? Was it through the company as a legal entity, or was it the members as a whole? And in this case, the court said it was the commercial entity of the company. The company as a commercial entity was considered. So the duty owed by the directors was to the company as a commercial entity. So now you have got two differing decisions. One says we don't take into account the commercial entity, we just take into account members as a whole, but Darwell seems to suggest that it is possible for us to consider the company as a commercial entity. All right? Now, individual shareholders, different classes of shareholders, interest of creditors. Fiduciary duty is not owed to individual shareholders. The exception was Galvanics and Brunninghausen that we looked earlier. If different classes of shareholders, directors must act fairly between them. So you may have shareholders, ordinary class A, ordinary class B, ordinary class C. All of them must be fairly treated. So that's what we are saying. Now, duty to creditors increases when solvency to the company decreases. And this is the case of Kinsella. Kinsella was involved in a business that never dies, funeral services. All right? So they were involved in funeral services, and this was a family-owned business with the family members being directors of the company. Now, at one point, what they did was that they had a major asset of the company, which then they gave on lease to their own directors, their own family members, at a rate below the market rate, and also gave an option to purchase the property at a future time. And after this transaction was done, what do you know? The company goes into liquidation. All right? So now the liquidator goes after the transaction and says, look, you have taken a major asset out of the bridge of creditors because you have now taken it away. Now creditors can't be paid, therefore this should be returned so that we can pay the creditors. And the court said yes. When the solvency of the company decreases, the duty towards the creditors increases. All right? So when the company is solvent, the general best interest of the company would be that of the members. But when the solvency of the company decreases, the best interest of the company would be that of the creditors. Okay? Right. Then we look at corporate groups. Now, directors in corporate groups owe duty to their individual companies and not to the group. So when you are in a corporate group has a wholly owned subsidiary, some subsidiary companies. So you are a director in a wholly owned subsidiary. Do you owe a duty to the holding company, or do you owe a duty to the subsidiary company? The law says you owe a duty to the subsidiary company. So it doesn't matter about the holding company or the group. But there was a case where they actually said that the betterment of the group was something that can be considered, and that was Equity Corp and BNZ. In that case, what happened was that two subsidiary companies gave an amount of loan to a third company, which they needed the amount to offset a loan that they had taken. Now, by doing this, the courts said that they were actually saving themselves as well, because if you put the group into a dire problem, the whole company, the group of companies will be affected. So they said in such an instance, it was still for the betterment of that subsidiary company to give this particular All right, but of course, this is a limited case, and this comes from a decision from New Zealand. Now, we looked at nominee directors of wholly owned subsidiaries. If holding companies' directors are appointed as nominee directors on the board of subsidiary company, whose interests should they look out for? Section 187 states that it applies to wholly owned subsidiaries. So general rule is, if you're a director of a subsidiary company, you owe the duty to the subsidiary company. The holding company directors are taken to have acted in the best interest of the subsidiary if the subsidiary's constitution authorizes directors acts in good faith and subsidiary is not insolvent. All right. Now, nominee directors as lenders. In Levin and Clark, if subsidiary company's constitution allows for the appointment of nominee directors, then the nominee director can act on the interests of the nominee that they are representing. All right? Otherwise, they will have to act for the benefit of the subsidiary company. I think you can deal with that. Interests of employees. Do the directors owe a duty to the employees? This was considered in Park and Daily News. In Park and Daily News, the company was going through, they had two companies which was going through difficulties, and they decided to sell the company off. And the proceeds of the sale was to be used to pay off redundancy packages to the employees. Now, obviously, one of the shareholders was not happy about the money being used to pay off employees or former employees, and therefore took an action, and the court said in this case that the directors owed the duty to the members first and then the employees. So even if your intention was good, the duty to look after the best interests of the company meant the best interests of the members as a whole. Okay. Now, if you get a question in this area, section 181 sub 1 sub B, we are looking at duty to act for proper purpose. In the exams, how do you know you're going to discuss an issue related to proper purpose? It will always be a situation where there is an issue of shares. All right? So if you read on the facts, it shows that there is issue of shares. You need to talk about section 181 sub 1 sub B. All right? So if you have issue of shares, that's the first thing that comes to your mind. It's no longer section 180, but 181 sub 1 sub B. Now, this actually is a situation where powers are given to the directors, and the question to be asked is whether or not the director has exercised the powers according to the legal reason the powers are given. Now, if you have the power to issue shares, what is the legal reason for issuance of shares? Why do we issue shares? Very good. To raise capital. Now, if I issued shares to reduce your shareholding in the company, have I exercised my powers for a proper purpose? If I want to dilute your shareholding in the company, assuming you now have 80% of the shares, I am now issuing shares to other people to dilute your shareholding to 30%. Now, have I issued the shares for the right reason? For a proper reason? The answer is no. The proper reason is to raise capital, but here my purpose of issuing the shares is to dilute his ownership or dilute his shareholding. So that would become improper purpose. Now, when you have a single purpose, there are two questions that you will ask. When you have one purpose, first purpose is, what is the legal purpose of the power? Second, what was the power exercised for? If the legal purpose and the power that was exercised is the same, then that is proper purpose. If it's not the same, that is improper purpose. However, this test will fail if you have an improper purpose and a proper purpose. So you have multiple purposes. In such a situation, you do not use the proper purpose test, you use the mixed purpose test. The mixed purpose test says, but for the improper purpose, would I have exercised the powers? Giving an example, I am now wanting to issue shares to my son. And my main reason is to issue shares to my son, and as a result of, and the second reason is to raise capital. But the question is, would I have issued the shares still if my intention was not to give benefit to my son? If the answer is no, then that is an improper purpose. If the answer is yes, despite the fact that my son may not get any benefit, I will still issue the shares, then that is a proper purpose. Now this is very important. You need to know both of the tests and you need to know the supporting cases because they carry very high marks if you're going to be tested in this area. Right? An example of the power to issue shares, you can see raise capital, replaceable rule 198A. In Western Ventures Proprietary Limited and Resources Equities Limited, the shareholders wanted to remove 3 directors and replace them. Just before the resolution was going to be passed, the directors issued 7 million shares to friendly parties and the resolution was defeated. So they were trying to defeat a resolution by issuing shares to a friendly party. The 2 cases that you have to mention, the first case is Howard Smith, that is the single purpose test. White House and Carlton is the mixed purpose test. So once you've discussed the single purpose test, you will discuss Howard Smith and Ampol Petroleum. Now what happened in Howard Smith was that Howard Smith, Ampol Petroleum and Bulk Ship Limited were the majority shareholders of a company called Miller Limited. They together owned about 55% of the shares. And they were about to make a takeover bid over Miller Limited. Now, Miller Limited's directors were not very eager to have Ampol Petroleum take over their company. So what they did was that they issued shares, more shares to Howard Smith, a friendly party to Miller Limited, and as a result of which the shareholding changed, which made Bulk Ship and Ampol Petroleum to have 32% of the shares, whilst Miller had 50%. So now Miller could do a takeover bid over the company. Sorry, Howard Smith could do a takeover bid over Miller Limited. And because of this issuance of the share, Ampol Petroleum was not successful in making the takeover bid, and that's the reason why Ampol Petroleum decided to take an action. And in this case, the court said, look, even if your shareholders were going to get a better deal from Howard Smith, it doesn't matter. The legal purpose of issuance of shares is raising capital, but you have issued it to defeat a takeover bid, and that was an improper use of power. Right? In White House and Carlton was a family company where the father and the mother separated. The daughters followed the mother, the sons followed the father. So the father didn't want the ex-wife and the daughters to have control over the property, so he decided to create a new class of shares and issued it to the sons. And subsequently, he fell off with the sons as well and decided to then challenge the validity of the issuance of the share. So that was the facts of this particular case. The allotment was invalid even if the directors honestly believed a share issue is in the best interest of the company. It will be invalidated if it is motivated by their desire to manipulate control within the company. So these are other examples of the powers other than the power to issue shares that has been looked at by the courts. So, issue of mixed purpose, I've already explained this. We are trying to find out what is the dominant motive in relation to that particular transaction. Right. So in a brief, we have done the fiduciary duty under equity. We looked at duty of care and diligence. We looked at the defenses related to duty of care and diligence under business judgment rule. And we looked at the duty to prevent insolvent trading and defenses related to that. And finally, we looked at section 181, duty to act in good faith in the best interest of the company and duty to exercise the powers for a proper purpose. All right? I'll see y'all. Thank you.
Yeah, sure.
Yes, it's an issue that I don't have my ID on. Okay. Do you have any ID on you? No, I don't. Fine. Okay. Yes.
We still need student ID, right?
If you've got it, then yes, but it's not a big deal. Yeah, so if you've got it, then that would be good. Okay. Yes.
I've got a code and access plan. Where do I sit?
Oh, wherever you like, and I'll just, I mean, yeah, I've got the list and it can be here, but I'll be a bit flexible with everyone's time, so it won't be, yeah. Best spot, to be honest, is in the middle of a row, because then no one will want to climb over you. Does that make sense? That would be what I'd suggest. How you going? Yeah, so I'm going to be fairly flexible at this time. Your best way is actually get someone working on one climb over. So if you don't do something that's your safest bet, then you want to be, that makes sense, and then because, yeah, exactly. So yeah, so relax it off.
Hi, so
Yeah, just so sit wherever you can, yes. Ideally space yourself out. Sorry? Yes. No, it doesn't matter where you sit. No. They don't have tests, but they're not my tests. I haven't given out any tests, so if they've got a test, they're doing the wrong one. Sorry? When we start? Yep. Once we get them out. So I'll give them a couple more minutes to arrive. Because it'll be messy to get all the tests out on time. So, yeah. So I'll wait till Anna's here as well.